Peter, great to see you and hear from you.
Yeah, I just saw you were reading something there, Trevor. What's you reading?
Interrupted me. I was reading a wonderful publication. I wouldn't call it bedside reading.
Okay.
But it's very nice to have. And that is Taxpayer's latest humble publication, being an index to articles and editorials in 70 years of the Taxpayer. That's from 1952 to 2021. I'm sure most people know that Meyerowitz, Silk and Spiro started the Taxpayer in January 1952. There was nothing else like it on the market. They asked Juta to publish it. Juta said they didn't think there'd be a market for it. So they said, okay, we'll take the risk. You just do the admin for us. And they almost immediately had 2,500 subscribers. So
fantastic.
This is an index to the whole thing. And the three parts to it. The first is an alphabetical index. So if you've got a particular issue that one wants to look at, you look under the alphabetical index. That then cross-refers to the Taxpayer, but also to the chronological index, which goes year by year, and that chronological index gives the full title of each entry. So the alphabetical doesn't always give the full title, but that's why it's cross-referred, and you can see whether it's what one wants. And then there's also an index to external subscribers, which Peter, you and I don't qualify as because we're editors, but we've snuck in through the back door because we've co-published with some other external people. Yeah, and I must say, while doing this, there were at least 7 or 8 occasions when I thought to myself, damn, I wish I'd known about this article when I did such and such a case, you know, because it would have been really useful to know. I didn't know about it, and I'm an editor of the publication. And what I think makes the whole thing useful is that most people, I would imagine, don't have access to 70 years of the Taxpayer. But by emailing info@taxpayer.co.za, they can get it, whatever it is that they want. Can be emailed to them. So everything is accessible. Anyway, that's not what we're here to discuss today. That's just what you interrupted me reading when your visage appeared on the screen. I'm doing too much talking, Peter. You take it away.
I think we're here to talk about a case, and the case is the Arena Holdings case that relates to disclosure of taxpayer information, which I thought was very interesting and very topical. I think the judgment was handed down in November last year, mid-November, and the case was basically, it was an application brought by the Financial Mails holding company, and it challenged the constitutional validity of the prohibition on the disclosure of taxpayer information in circumstances where the disclosure would show a substantial contravention of law and be in the public interest. And it was interesting, the fact is basically about the Financial Mail trying to get the tax records of Jacob Zuma. And they claimed that he hadn't submitted tax returns for the first 7 years of his presidency. And also that there were substantial fringe benefits tax owing in respect of the refurbishment of Nkandla and various other payments. So the Financial Mail basically wanted to get their hands on Jacob Zuma's tax records, and they weren't able to do so through the normal channels. So they went to the court to try and find a constitutional remedy. So quite interesting, because Section 32 of the Constitution provides for rights to access to information. So that provides the framework for getting access to information. And then the Promotion of Access to Information Act, PIA, was enacted in terms of Section 32. And PIA talks about various disclosures. And for example, it says that access must be given by a public body, for example, SARS, to a record held by it when requested. And the information must be given to the person requesting it. So there's a prohibition if somebody other than the person requesting it gets the information. So there's also, PIA is also quite interesting. It's got what's called a public interest override, where it says there must be a disclosure of information if it's in the public interest and if it shows a substantial contravention of law. So Trevor, that's quite interesting, because that sort of takes us directly into the applicant's case. That's what they were arguing, that there is a substantial contravention of law and it's in the public interest. The problem with using PIA is that PIA excludes taxpayer information. So it says this public interest override doesn't apply in respect of taxpayer information. So it specifically excludes taxpayer information. So then you have to go to the TAA, the Tax Administration Act, to work out what taxpayer information is. And that's very broadly sort of any information in relation to a taxpayer that SARS has, and that they've got either from that person or from anyone else. So any information that SARS has about you or anyone else, that's taxpayer information. And the TAA basically says that a SARS official must preserve the secrecy of taxpayer information and can only give it to another SARS official. They can't disclose it to the public. They can't disclose it to somebody who's not a SARS official. A couple of exceptions to that, but very limited exceptions. So, for me, it's quite interesting that in terms of our law, there's no basis for tax records of Jacob Zuma or anyone else to be provided to the Financial Mail or any other person. So I think the law is pretty clear. And so the Financial Mail had to come and basically say, hang on, but that's constitutionally invalid. So it was a constitutional challenge to the existing law as it stands. And, the court held that there's a sort of a tension between the provisions of the Constitution on the one hand, and then PIA and the TAA on the other. And it held that, just reading from it, it says, once the balance of competing rights tilts in favor of SARS, the declaration of constitutional invalidity must follow. And conversely, if the balance tilts in favor of SARS, the statutory provisions must be left intact. So they say, you need to see which way the balance tilts. I don't know what your sense of that is, Trevor.
The competing interests were, in terms of the Constitution as well, were the right to privacy and the right to dignity. So that those are also rights protected by the Bill of Rights. And so that competes with the right to information and the right to publish. And we have yet to find out what the Constitutional Court will have to say about it.
Yeah.
Because it's heading there, isn't it?
It's heading there. And it's interesting because SAR's argument was that confidentiality is what the taxpayer gets in return for the compulsion to provide information to SARS. So SARS argued that without the guarantee of confidentiality, taxpayers won't be candid with SARS. They won't give all of the information that SARS requires to SARS. So that was their argument, is that it's a quid pro quo. If you, the taxpayer, tell us all your private information, we'll look after it and we'll keep it secret and we won't disclose it to other persons. So, that was SARS's argument.
Now, let me ask you a question. I genuinely don't know the answer to this. What do you think about it? Which way do you think a court should go?
I have quite a strong sort of I have a kind of a sense of, and we've grown up, Trevor, as tax practitioners. So to me, taxpayer information is sacrosanct. And I think that once you provide it to SARS and they have it, I don't think it should be disclosed to third parties. And, I don't think this public interest override should interfere with that. I think it should be a principle that stands on its own and is not subject to exception. And, and I think that's kind of just the way that we've grown up. And often when you talk to taxpayers, they take a lot of comfort from that and the fact that the information is safeguarded, if you like, and can't be bandied around. And yes, it's a limited exception because there has to be public interest and there has to be a contravention of law. But my instincts are not really in favor of it, and especially because the law, I think, on this is clear. So if the law is clear, then it's clear. The legislature has spoken. Why try to go to the Constitution? So. Yeah. But it's an unbalanced view, Trevor. It's an instinctive view, I think.
I'm happy to say I agree with you 100%. and partly my thing about it is what lies, the real motivation that lies behind this application is political. One way of having a go at some politician that you don't like is to try and force them to disclose information which you say there might be irregularities and things like that. And one remembers when Donald Trump was president of the United States, a lot of people didn't like him. They wanted to have a go at him to disclose his tax returns. But behind that is politics. It's not, and I don't think a taxpayer's, what the Act calls taxpayer information, should be a political football to be kicked around. I seem to remember sometime in the past that one of our controversial politicians, that there was talk about that person's tax affairs, and I'm by no means a supporter of that person whatsoever, but I really felt it was wrong just to bring tax into it. To me that's a low blow.
And an interesting point is because the court rejected SARS's argument about this quid pro quo, because it said, if SARS gives taxpayer information, or rather taxpayers give information, because if they don't give information, then they're subject to criminal sanctions. So it's not because it can't be disclosed, it's because they're scared of the criminal sanctions of not fully disclosing with the disclosure requirements or complying with the disclosure requirements. So that was, so that was the kind of the court's perspective. I also am not sure that that's the reason why taxpayers' information should be confidential. I think it goes further than that. I think it's not linked to the fact that taxpayers will only fully disclose if they know the information is not going further than SARS. I think it's a wider point than that.
I agree. And just listening to you talk reminds me, in a recent issue of the Taxpayer, there was reference to the oil well case, which is a case dealing with exchange control. And Harams JA made the point in that case that where legislation imposes either criminal or administrative penalties, it must be interpreted restrictively. Now, I don't know what restrictively means in this context, but I would think the conservative, why must SARS officials run the gauntlet, as I think you just said? They're entitled to interpret it restrictively because they're under threat of committing a criminal offense, which I have to say, I've noticed in the past, certain taxpayers' tax affairs have been broadcast on the front page of weekend newspapers. not every week, but it has happened. And the prohibition, if I remember correctly, applies not just to SARS not being able to do it, but anyone who receives information from SARS, they also commit an offense if they publish that information to the public generally.
I was going to come on to that, Trevor, because I think often we see letters addressed to taxpayer clients of ours from SARS, and they contain information relating to other taxpayers. Yeah. So there's often a sort of an instinctive response from our clients and saying, but hang on, why am I hearing about some other taxpayers' affairs in this letter that's being written to me? I didn't know about any of that stuff. The ABSA case that we talked about that was taken on review successfully, sort of, I think, included that because ABSA was at the end of a chain of companies and didn't know what was going on in respect of the other companies that related to a third-party bank. And ABSA were told about the activities and tax information of those other parties from SARS. And I think, as I say, there are limited exceptions where SARS can reveal taxpayer information. And one of them is where it's necessary for the relevant taxpayer to understand the question SARS is asking. Yeah. But I think sometimes there is at least a question around this confidentiality of information and whether it's being complied with. And
I think there's a judgment of Judge Corbett on that point. From memory, Commissioner for Inland Revenue versus Lowe, case with tax avoidance, because often that would happen in a tax avoidance context, as you say, with ABSA. There'd be other parties involved, and I think Corbett warned against violating the taxpayer confidentiality provisions.
So I was also raised the question of DTAs, because DTAs are brought into our domestic law, and DTAs have certain prohibitions against disclosing information, except through certain channels that the DTA kind of specifies. So SARS said, but hang on, if we open the gates to this public interest override, does that apply to DTA information as well? Because we have separate obligations in terms of our double tax agreements with other jurisdictions. Yeah. And we won't be in compliance with those obligations if we start revealing that information outside of the DTA framework. So the court sort of didn't really deal with that. It just said, well, maybe that won't be in the public interest. So it's, bring in the public interest override and then say that it doesn't apply in respect to the DTA information, but it didn't really deal with that aspect.
Yeah, but the judge in the arena case that we're talking about, Judge Davis, and I emphasize not Dennis Davis, who's now retired. It's Judge Norman Davis in Pretoria, but he was in favor of the applicants. He held that you've got to read something into, I think it's section 69 of the Tax Administration Act, but of course it has to be submitted to the Constitutional Court to be confirmed. Is that correct?
Yeah, he held that the limitations on the access to information are not justified, and that the public interest override is justified. That was his finding, and the order of the court was that the relevant provisions of PIA are unconstitutional to the extent that, firstly, they only allow access to the tax records of the person requesting them. Secondly, they don't allow access to the tax records which meet the public interest override. And thirdly, that they don't allow a person who gets the information to disseminate it to another person. So on 3 grounds, he held that PIA was unconstitutional, and the declarations of invalidity were suspended for a period of 2 years in order to enable Parliament to rectify these defects. And then pending the defects, he basically ordered that the records be produced and handed over to the Financial Mail. So found very strongly in favor of the applicant in this case. SARS applied for leave to appeal. So
yeah. As part of the hearing, I'm just looking on my iPad for the end of the case. The declarations of invalidity in paragraphs 1 and 2 are suspended for a period of 2 years from the date of this order to enable Parliament to correct the relevant defects.
Yeah.
And then presumably the matter will go to the Constitutional Court in that time.
I think it will, but it's interesting that he actually said that they need those tax returns for 2010-2018 needed to be handed over and provided to the applicant within 10 days of the order.
10 days, yeah.
And then SARS applied for leave to appeal. So that's
that's not suspended for 2 years. It's only the declaration of invalidity.
So leave to appeal
but can they publish it?
That's what I'm thinking. I don't think so, because I think of the fact that they applied for leave to appeal, I think suspends that.
That's right. Yeah.
I don't know what your sense is. Trevor, do you want to wager 10 Rand on this being overturned on appeal?
I'm prepared to put more than 10 Rand on that.
But I think we're both on the same side of the bet, so that's our problem.
That is the problem.
I think my sense is that it will be overturned, but who knows?
No, I'm inclined to agree. And if I mean, I reread the public prosecutor versus SARS case this morning, and that also seemed, that there were other complications there. The public prosecutor was had subpoenaed also former President Zuma as a witness, and claimed that overrode the secrecy provisions, her powers under the Constitution. She said that her powers were umbilically linked to the Constitution, and the court was not with her. But the facts there were different, and the provisions were different, so it's not directly in point. I'm only making this connection now while I'm talking to you, but I was looking at a thing this morning. I'm involved in a matter where a corporate taxpayer, had not paid PAYE on certain fringe benefits given to employees. They discovered their error, they did a VDP, and the tax has now been paid. And now they want to recover the tax, which the Act entitles them to do, from the taxpayer. So they've sued the tax, issued summons against the taxpayer, and the taxpayer has now requested copies of relevant information, including the VDP application and supporting documents. And the problem is that the VDP application doesn't just deal with the one taxpayer, it deals with a number of taxpayers. And so they want to give a redacted version of the VDP application, redacting information which applies to other. Now, they haven't received that from SARS. They actually gave the information to SARS. But it just seems to me that the same sort of consideration should apply, that other taxpayers wouldn't like their details of their salaries, etc., to be bandied about in a public arena. So, but maybe I'm just generally speaking in favor of secrecy, but I don't think so.
Yeah,
the problem is,
agree.
if the judgment of Davis J was upheld, where do you draw the line? You know, you can say, okay, the president of the country is a public figure, so his affairs are in the public interest. But then they'll start testing the boundaries, and where's it going to end?
Mm. And I think what sort of, irks me a little bit as sort of a tax lawyer is just that the law on this is clear for once, not once, but the law is clear that you cannot provide the taxpayer information, in this case to the Financial Mail. They're not entitled to it. The public interest override in PIA specifically doesn't apply in respect to taxpayer information. And this is almost a way around that to say, well, let's go to the Constitution, because that's, doesn't one always say that when you run out of other legal arguments, you kind of try and raise a constitutional point. So I think that's sort of, one of my sort of aspects that sort of irks me a little bit, that as I said, the law is clear on this, and the Financial Mail is not entitled to it. And your point, Trevor, that it goes to sort of the banding around of taxpayer information, which is by its nature confidential. And you can say, okay, well, it's subject to public interest, but when is, then you get into a debate around what public interest is, and also a debate around what a substantial contravention of law is, and I don't think you want to be in that. That's, for me, slightly quicksand territory that you don't want to be there. You want to have a very clear principle with no exclusions.
And another thought, another thought just occurring to me now, are the tax court proceedings are secret. So that kind of goes together. Why is that the case? So we have a culture in this country that certain things are between the taxpayer and SARS, and either party can appeal it further, and then it becomes public knowledge. But certainly initially, it's not public knowledge.
And I think that's exactly, it's articulated the point I was trying to earlier, saying that's the way that we've grown up sort of as tax lawyers. That's what the principle I think is important to us, because it it cuts through a lot more than just these provisions. It goes to the tax court, etc. And it also, we're in an environment where tax disclosure is becoming talked about more and more. And I'm talking about disclosure by taxpayers or about taxpayers to SARS and to the revenue officials around the world. And this, to me, undermines that, because if people say, of course, my information must go to SARS. If I've got an offshore trust, which I haven't, if I had an offshore trust, then SARS should know about it, and they should know what's in it, and they should know about how it's funded, and they should know about the income. But as soon as you say that, then I think there's more of an onus on SARS to keep it confidential, because there's a lot about that besides just being a taxpayer, that's no one else's business. So I think that the world sort of, going to this stage of massive multinational disclosure through CRS and FATCA and DTAs and Section 46 there's more of an onus on SARS to keep that taxpayer information confidential, as far as I'm concerned, than if you're just telling them what you earn as a salary. You're telling them very sensitive information around, your activities, your family's activities. And there's enough of a privacy debate as it is around keeping information private. And to me, it sort of ties into that bigger discussion around the privacy of information, if you really want to extrapolate. It's got nothing to do with other people, and a lot of this information. So that's where my head is.
I agree. I was listening to something this morning, and I'm going off at a tangent now, but about the way governments are not candid with their voters. And I don't know if this information is correct, but the person concerned was saying that someone approached the United States Supreme Court for disclosure of what funds that were made available by the Federal Reserve Bank after the 2008 crisis. And what was known previously was that $5.5 trillion was made available to various American institutions. But the Supreme Court found in favor of the people requesting the information. Turned out the Fed made $29 trillion available, including other governments, et cetera, et cetera. So, that information had been withheld from the population. So that's a totally different discussion to what we're talking about here, and let's not go any further there. But I mean, there's some privacy which is not good, and there's other privacy which is good, and what we're talking about this evening, I think, it's essential.
I think so.
Yeah.
So we've decided, we just need the courts to decide as well. So
perhaps we should offer to write the judgment.
Speak again. We will speak again on this topic, no doubt.
Yeah. Can I mention one thing in conclusion, just again, to do with the Constitutional Court? I was involved in a matter, it's a reported judgment, Turvest Financial Services, a VAT case. And the taxpayer applied for leave to appeal to the Constitutional Court. And the registrar issued a notice, mentioned, it said quorum, and named 9 judges. So 9 judges took this decision. Well, I'm sure it's just a few judges who look at those applications, but the 9 judges made the decision. And they simply said that I don't have the wording in front of me, but that the application did not engage the jurisdiction of the court. So if you ask, so leave to appeal to the Constitutional Court was refused. So if you ask the question, why was leave to appeal to the Constitutional Court refused? The only answer one can give is because it didn't entertain the jurisdiction of the Constitutional Court, which to me simply raises the question, why didn't it engage the jurisdiction of the Constitutional Court? Not a word about that. And there was, in my opinion, a constitutional issue. And no, I don't. Maybe I'm not suggesting the judgment is necessarily wrong, but surely, as taxpayers or as citizens, we're entitled to reasons. They don't have to be. I know it's only an application for leave to appeal, and you wouldn't write a 20-page judgment about the reasons for it, but half a page would help. It's just and that would guide other taxpayers, because the Big G case dealing with Section 24C and the Clicks case also dealing with 24C, those were allowed. This case, I would have thought, it did have a constitutional issue. The judge relied on an explanatory memorandum. If you remember what was held in Marshall's case in relation to practice notes, it raised that issue. But anyway, a little bit of a rant. Let's hope for good decisions from the Constitutional Court.
That's a good introduction to 2022.
Indeed it is. Yeah. Well, not for me to say, but good judgments mean good reasons to be given.
I agree.
Of course, it's always a matter of opinion whether reasons are good or not, and that's why we bother to have these discussions. But at least some reasons would be helpful. So as the new year got off to a good start, Peter. We're in February already. Can you believe it?
We are, and looking forward to many more podcasts as well, Trevor. So
that's
a lot. Nice discussion.
Yeah, we'll keep the fun going.
Well, thanks a lot.
Thanks very much. Always nice to see you.
Yeah, you too.
Bye-bye.